In this video, we are going to be talking about the 4 different types of restraining orders in domestic violence cases in California and what you can do about them. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, we're going to be going through those 4 different types of domestic violence restraining orders that can exist if you have a domestic violence case in California, whether it is in family court or whether it is in criminal court. So let's jump right into it. The first type of restraining order is called an emergency protective order. These come about when the police are called, they come out for a domestic violence call, they speak to the alleged victim, they determine that they are going to arrest the other party, and they ask the alleged victim, do you want a protective order? If the alleged victim says yes, then they will give her a sheet of paper. It's one single page. It will have a brief description of the facts, and it will expire in usually about 10 days or on the date of the first court date. Now, these emergency protective orders are not going to go on your permanent record. What I typically recommend, and usually by the time I talk to anyone who has one of these on them, is simply to let it expire. It will go away on its own. Number 2 is a TRO, or temporary restraining order. These types of restraining orders come about when one person decides to go to the court and within an hour, a few hours, fills out some paperwork, gives it to the judge. The judge looks over a whole stack of these in a matter of minutes and decides whether to either issue the temporary restraining order, or sometimes if there's really not a lot in there, if the person who was filling it out really didn't know what they were doing or what to say, the judge will say denied until hearing. So they won't issue any orders, but they will set up a hearing. Now, what to do about these? So these last about 21 days until the hearing. The date of the hearing will be on the first page of the document. The only way to get rid of this restraining order before the 21-day mark is if the alleged victim changes their mind. They can actually go into court and ask for it to be removed. Typically, that doesn't happen, of course. They have just requested this, so it's unlikely that they're going to just change their mind. So the only other way to defeat one of these temporary restraining orders is to go to the hearing that's on the first page. And that brings us to the third type of domestic violence restraining order, which is called a DVRO. It's just called a domestic violence restraining order. Now, the domestic violence restraining order only happens after the TRO. So basically how it works is, so the TRO is issued. The judge only looks at the paperwork for a few seconds, right? A minute, maybe. Issues the TRO or denies it until the hearing. And then at that hearing, the judge will decide, am I going to issue a domestic violence restraining order, which can last for up to 5 years or not? The temporary restraining order expires at the time of the hearing. So sometimes what will happen, unfortunately, especially in some really crowded courthouses, is that you will show up for that date on the temporary restraining order paperwork, and the judge will say, well, we don't have enough time to hear the case today. And the judge will then set another hearing date. Now, the problem is that then the temporary restraining order will be extended until that hearing date. If that happens, what I would encourage you to do, let's say that you are living in your car, or you can't see your kids, or you're sleeping on a friend's couch, or you're paying so much money to Airbnb so you have a place to stay, or a motel, is tell the judge that and ask the judge, Your Honor, can I please have an earlier date if there's anything that is on the court's calendar I am dealing with, and explain the issues very briefly. The judge may unfortunately say no, but that's really all that you can do. When I've made this request on behalf of my client, sometimes they'll send us to another courtroom, or sometimes they'll say, hey, if you don't mind waiting around all day today, we can probably hear it in the afternoon. And then of course I say, yes, let's hear it in the afternoon. Okay, so now let's turn to the domestic violence restraining order and get into more about that. So those come about, again, when the petitioner, the person who requested the TRO, shows up for the hearing, and the judge hears from both sides, and the judge has to decide that one side is more credible, so slightly more than 50% more credible than the other. And it's up to the petitioner to show that they are more likely than not telling the truth. What you can do about it, as the respondent, you can present as strong of a case as possible to try to convince the judge that the judge should find that you are more credible than the petitioner. Now, how do you do that? There are so many things that I can't fit into this video that you can do to appear credible, to show that the other party is lying, to prevent the other party from getting their evidence in, from making sure that you get your evidence in. And I actually teach people how to do that if they want to represent themselves in a restraining order hearing. I have a course called Defeat the DVRO in which I teach you what the objections are. For example, the other side tries to show a video at the domestic violence restraining order hearing. You say, objection, foundation. They don't know what that means. Maybe you don't know what that means, right? And I didn't know until I went to law school what that meant. But the judge does know. And if the other party isn't able to establish foundation, basically where the video came from, what it is of, how she knows that it is whatever it is, then the judge will not let that video come into evidence. Now, that's just an example of one thing you can do to win your restraining order hearing. I mean, another example is, let's say that the petitioner writes something in their paperwork, they describe some event of abuse, and then they change their story at the hearing. How do you point that out to the judge? Don't expect the judge to just notice. The judge all day long for 8 hours a day is hearing these things, and the judge who is sitting there watching the evidence, deciding, probably isn't the same judge who looked at the whole big stack of paperwork for TROs. So may not know the paperwork that well. Now there is a technique to do it and it's not that hard. Anyway, so in the course that I teach called Defeat the DVRO, I teach you all of these things. I teach you everything that you need to know to have your best chance to win. You can get your free first class on that. There's a link down below. If the judge decides that the petitioner has presented enough evidence, has convinced the judge slightly more than 50%, then the judge will issue a domestic violence restraining order. These can last for up to 5 years. If you're at that hearing, if you lose, God forbid, right? If you find yourself losing, what you can do at the end of the hearing is you can ask the judge, and make sure not to interrupt the judge, but you can, sort of raise your hand a little bit. If there's no pause, you can say, Your Honor, if you are inclined to grant the domestic violence restraining order, then I would ask you to please grant it for a year rather than 5 years or 3 years. 3 years is very typical because I am very concerned that it's going to affect my employment, licensure, whatever it may be. This is one that will show up on your record. The temporary restraining order will not show up on your record. The emergency protective order will not show up on your record, but this DVRO, it will show up on your background check. It's not a conviction, but it still shows up on a background check and obviously doesn't look good. So you want that off your record as quickly as possible. Okay, now let's talk about the fourth type of domestic violence restraining order. This is a criminal protective order. Now, how did these come about? If you are arrested for domestic violence, and that could be PC 273.5A, could be PC 243A1, it could be even some form of child abuse or something involving family violence, at the very first court date, which is called your arraignment, if charges are filed, the district attorney, the prosecutor, is going to ask the judge to issue a criminal protective order. Now, if you find yourself in this situation, you may be thinking, okay, but the alleged victim doesn't want that. They want the whole thing to go away. That situation is very common. The prosecutor does not give a you-know-what about that at all. What can you do if you are in that situation? If you're thinking, we definitely don't want a criminal protective order. I mean, this criminal protective order will stop the two of you from being able to contact each other. If you live together, you have kids, that's obviously a huge problem. So there are two things that you can do. The person who is arrested, the person who's facing criminal charges, can start taking domestic violence classes right now. If you're watching this and you have that court date coming up, start taking them right now. And take one per week and bring proof of that to your first hearing date. So that's number one. And by the way, taking those is not an admission of guilt. It's not seen as an admission of guilt. I know that may seem counterintuitive, but it's true. Typically, what will happen is if you don't do that before the first court date and the judge decides, well, I'm going to issue this criminal protective order, sorry, husband and wife and, kids, but why don't you take some domestic violence classes and ask again at the next court date? Well, if you have started taking those domestic violence classes in advance, now you can say, well, Your Honor, I've actually already taken some. And you will be the gold star A+ student, and that will help quite a bit. Now, that will only help if the alleged victim does not want there to be a criminal protective order. If the alleged victim wants there to be one, then that's not going to help you. There is going to be one until the case is over, at least. And the other thing that you need to do, and this is mandatory, if the alleged victim does not want there to be a criminal protective order in place and wants to be in contact with you, the alleged victim needs to show up for the first court date, and your defense attorney needs to help facilitate the alleged victim being able to address the judge. Now, I know that sounds scary. It's really not. What happens is that if I'm the defense attorney, I tell the DA, hey, the victim would like to be heard. She does not want there to be a criminal protective order. She's here. You can go talk to her. I have to give them that chance. And then when the case is called, I say, Your Honor, the alleged victim is here. She would like to be heard. And in the meantime, the alleged victim's like, well, what am I supposed to say? What the judge is looking for is for the alleged victim to say, I do not want a criminal protective order. I'm not afraid of the defendant, whatever the defendant's name is. And if the defendant were to be violent with me, I would call 911. Now, I know, again, that last part sounds so counterintuitive, but that is what the judge is looking for and what the judge needs to hear. So you may be thinking, I don't want to say that I don't want to make it seem like there might be future domestic violence between us, but trust me, that is what the judge needs to hear. You know, I actually had a situation not too long ago where I was representing someone whose mom and fiance, he was in jail. Both of them had made claims of domestic violence of various sorts against him. So at the first court date, and I didn't represent him at that time, there was a criminal protective order put. So he couldn't call either one of them from jail. So they hire me, I take over the case, and I tell them, hey, this is what you need to say to the judge. If you want the criminal protective order to be lifted so that he can call you from jail, which I know you both do, here's what you say. Now, immediately the fiance begins arguing with me, and she says, I'm not going to say that last part. He's in jail. That's stupid. I'm not going to say that. Why would I call 911 if he's calling me from jail? And just didn't believe me. And she said, you know, I'm just going to tell him that this whole thing is BS and the charges need to be dropped and the protective order needs to be dropped. And I'm just going to give him a piece of my mind of what I think about these charges. And I'm like, I don't think that that's a good idea. I don't think that that is going to work. Like, please, I know he wants to call you. You want him to call you. Follow my instructions. So I tell the judge that they would like to be heard. And the mom stands up first. She follows my instructions exactly. She's looking at me like, this better work. But she follows them exactly, and the judge lifts the criminal protective order for her. Now, the fiance had been in the hallway. She didn't see what just happened, but she came in and she did exactly what she said she was going to do. She starts yelling at the judge, complaining about the charges, complaining about the case, didn't say any of the things that I asked her to say. I tried then to save it, lead her, and ask her, okay, but if he were to, for example, threaten you, or if he were, for example, to bond out of jail, if there were any sort of domestic violence, you would call 911, right? She wouldn't say yes. I know she probably would call 911. She'd called 911 on him many times in the past, but she wouldn't say yes. If you're in the state of California, please trust me on this and ask your defense attorney. They will help you as well. Now, typically, the judge will not say in these cases, I'm just going to remove the protective order altogether. What the judge will do instead is make it what's called a level 1 protective order. Level 1 protective order means that you can have peaceful contact. So you can't, it says on there, you can't harass, strike, molest, all these different things that you can't do to the other party that you can't do anyway. So it is essentially like not having a protective order. The only thing is if you were to do any of the things on that form, if you were to harass, strike, molest, then it's an additional criminal offense. So how long can these criminal protective orders go on for? The criminal protective order can last for up to 10 years. So let's say that the victim is very adamant that they do want this protective order, or for some reason, and this happens usually only in much more serious cases where the defendant is in custody, the judge, and can't do any domestic violence classes, the judge simply refuses to lift it, then there can be a 10-year protective order in place. To get rid of it, the victim will need to go back into court and again tell the judge that they want it to be terminated, that they are not afraid of the defendant, and that if anything were to happen, they would call 911. I hope you found this video helpful. If you do have a domestic violence criminal case in California, feel free to give me a call. You can find my number down below. And if you have a restraining order case in California and you are thinking about representing yourself, go ahead, go to www.defeatthedvro.com, get your free first class. You have nothing to lose. And all of the information that is presented there is presented in a concise, easy to digest format, so you make sure you don't miss anything trying to go through YouTube and find the answers. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell.